Hello and welcome to Manika IAS. So in the previous video we had discussed about the type of majority, and we also said that in the upcoming video we'll be discussing about the application of majority when it comes to amendment of the constitution, right? So in this video we'll be discussing about amendment to the Constitution of India. So what does the term amendment implies? Amendment in the very simple terms implies any change, be it by the means of omission, that is removing something, deletion, some substitution, किसी terms को किसी के साथ substitute करना, or some addition of articles or provisions into the constitution. That is your amendment to the constitution. And how can this be made? See, there are two ways by which amendment can be made to the Constitution of India. One is by simple normal bill, ordinary bill, and when we are talking about a simple ordinary bill, these amendments are not called constitutional amendment. They are simple bill, right? So the act will also not be called as Constitutional Amendment Act. It can be done by simple normal ordinary bill, right? However, when it comes to the amendment which are made under Article 368 of the Indian Constitution, Article 368 deals with the power of Parliament to amend the Constitution. Any amendment which is made under the ambit of 368 is referred to as constitutional amendment, and thus the bill or the act is referred to as Constitutional Amendment Act. Now, before coming to this part, let us discuss why there are certain provisions which are amended by simple majority and what are those provisions. So, the amendment which are not constitutional amendment are done by simple majority. Simple majority, as we discussed, is more than 50% of present and voting. And if any of you has not yet studied the type of majority, links will be somewhere here. You can please click on the link and read the majorities and then come to this section. It will be very well understood then. Okay, so you first read that and then come and read about the amendment to the Constitution. So there are some provisions such as admission or establishment or formation of new states, which can be done by simple majority, and then changes in second schedule, fifth schedule, sixth schedule, then changes with respect to the matter of parliament, that includes quorum or rules of procedure, salaries, allowances. There is a list of these provisions, and this is a very factual thing. You have to memorize this. You will get it from the notes that you will get. So please remember all these provisions. This is important from your preliminary point of view, right? So this is done by simple majority, right? Now come to Article 368. In Article 368 also, there are two type of amendment that needs to be done. One is by special majority type 2. That means more than 50% of total strength plus more than 2/3 of present and voting, as we had already discussed. Now this type of majority is required. Majority of the provision in the Constitution of India are amended by this particular type of amendment, that is special majority type 2, right? It also includes your fundamental rights and DPSP and any other provision which is there not mentioned here or not mentioned here, that we'll discuss soon, will be amended by special majority. So majority of the provisions are amended by special majority, but some are by simple majority and very few are by needs ratification of state. Okay, so and the second type is your amendment which also demand ratification of state along with special majority type 2. So ये वाला majority तो required है, ये majority parliament से required है. Okay, अगर parliament ने इस majority के साथ if they have passed the bill, then there are few provision that need to go to states. Now 50% of the states must pass the bill which is passed by the parliament by this majority with a simple majority in their respective legislatures. Right? So how it will be? There are certain provisions that need to be amended by special majority by the parliament, plus they require ratification of the state. Ratification means 50% of the state must say yes to that particular bill, and that too with a simple majority in their specific legislatures, right? Now what are those provisions? So if you read Article 368, Article 368 has clearly mentioned those provisions that need to be amended using state ratification. And what are those? Let us discuss. See, election of president. Article 54. Article 55, manner of election of president. Right? Article 73, extent of executive power of union. Center का executive power कहाँ पे है? That is Article 73. And then Article 162, extent of executive power of state. Article 241, High Court of Union Territories. 279A, GST. Then Chapter 4 of Part 5, Union Judiciary. Chapter 5 of Part 6, High Court of States. Chapter 1 of Part 11, Legislative Extent Relations between center and state. Then you have 7th schedule. 7th schedule contains 3 lists of subjects: center, state and concurrent. That means it contains the topics or the content on which the parliament or the state or both of them can make laws. Okay, so it contains those subjects. So, and then representation of states in the parliament. Now, this is something that you need to remember, but one question that should come in your mind is, why is it that these are the specific topics which need state ratification, and why is it so important that Constitution under Article 368 has explicitly mentioned these topics? Because all these topics are dealing with the power of state. So as we all know, India is a federal nation, right? So federal means there is a balance of power between center and state, right? So if you will change any of these provisions, it will shift the balance of power in one direction. Say for example, if union make any changes with respect to these provisions, right, on its own, it will somehow take away the power of the states. That's why it requires state ratification also, because to maintain the federal balance. Say for example, president is head of state. It is not the head of the union. So why is it that only union can change the election to the president? Because when state is also a party to election of president, then state should also has a say in changing the manner of election, if at all there is a need, right? Similarly, if union go ahead and change the extent of their executive power or extent of executive power of state, it can shift the balance of power in their direction. So in order to maintain a federal balance, it required that these topics also need state ratification to change the Constitution of India, right? So this was about the amendment to the Constitution. In next topic, we'll be discussing about fundamental rights. We are starting with the fundamental rights from the next video. Till then, if you have any questions, any doubt, you may please ask in the comment section below. Thank you. Have a nice day.